For admission, item 14, Criminal Division 116 of 2019.
What happened in mediation?
Mediation has failed.
लास्ट ओकेजन मेडिटेशन के लिए रखा गया था, मेडिटेशन फेल हो गया। माय लॉर्ड, हमारा यही सबमिशन है कि हम देने के लिए रेडी हैं, लेकिन एक बार एक काइंडली फिर से रेफर कर दिया जाता। हमका इंस्ट्रक्शन आया हुआ क्लाइंट से कि
नहीं हो सकता। आप बताइए, रेडी है तो बताइए कितना देंगे।
3 लाख रुपए देने के लिए रेडी है, इन इंस्टॉलमेंट देंगे।
बेल बॉन्ड कैंसिल कर देंगे, इंस्टॉलमेंट में देते रहिए।
मुझे दे दिया गया, ऐसे तबीयत खराब था उनका।
नहीं, आप आराम से देते रहिए इंस्टॉलमेंट में। जब इंस्टॉलमेंट पेमेंट हो जाएगा तब आपको रिलीज करेंगे।
हम लोग को बात हुई थी उन लोगों से, और यहाँ तक कि हम लोगों का डिसीजन मतलब लास्ट फाइनलाइज हो गया था 3 लाख में।
आपको अब एक दिन का भी समय नहीं मिलेगा। आप बहस करने की तैयारी करें। NI एक्ट में जो है ना, मजाक बना के रख दी। Concurrent finding, compensation is 6 lakhs rupees. Rightly so. नहीं हो सकता, कुछ नहीं हो सकता।
नोटिस हुआ था, उसका रिसीप्ट भी ये लोग नहीं लगाए।
कोई जरूरत नहीं
फाइंडिंग में आ
है।
गया
वो तो मेरिट का बात है ना।
जी,
So
जी।
I want you to argue on merit. We want you to argue on merit. What is the date of notice? रिकॉर्ड आ गया है। Yes, you tell us. What is your point?
The lordship, the case number 138 is not constitutional in the present case, because he has served only one notice. That too he has not served, and the receipt of the notice was not.
What is the mode of service of notice? You go through the LCR. The records have come. We will hear you tomorrow. But you go through it, both of you. Criminal Revision 116 of 2019. The counsel for the parties are present. A mediation report has been received stating that the mediation has failed. The records from the concerned court has already been received. Counsel for the petitioner prays for adjournment to go through the records. Let the matter be posted tomorrow. The parties may go through the record today itself. लीजिए, देख।
Item 15, Criminal Division 584 of 2021.
Respectfully, challenging this case. Whether in this case I have instruction to appear in this case. By tomorrow I will file Wakalatnama matter to let it come.
Concurrent findings. It is against concurrent
It
findings.
is not emanating from the proceeding of 125.
Oh, 125. You are for the
Wife.
wife.
Lord, I have some instruction from my client. Lord, just 2 months or 3 months before, my Lord, there was conversation between the parties.
Please don't. We do not know.
Not the only
If
ground
there
of
was conversation, the opposite party number 2 must have
for
been
the first
detained.
time.
I will seek instruction on that point also.
And my Lord, the only point of mine, my Lord, in order to challenge this impugned judgment is, Lord, that affidavit of disclosure, Lord, has not been invited by both the parties. And my Lord, I am relying upon my Lord's decision, etc. Otherwise, so far as maintenance amount
This has
is
been
concerned,
passed on 27th of August 2021. And what is the date of judgment of
Lord, that was of course not subsequent to this judgment. But
That
then,
was
my Lord,
subsequent to this
but then,
judgment.
my Lord, what is important is that, my lord, so far as
What is the
quantum
date of that judgment? What is the date of that judgment? 2018. Raziz versus Neha.
No, not.
This
This judgment impugn.
Is to 2021. So where do you say 2018?
no, it's a judgment of 27/8/2021.
Right. Fourth November 2020 is the
So,
judgment.
Lord, this judgment is subsequent to. And Lord, so far as
Mr.
maintenance.
Karnkar,
Yes.
the point is that in case of dispute of this nature, where there is dispute regarding quantification of the maintenance amount, the required disclosure was to be made before the court concerned. And how much is the compensation fixed?
Lord, 10,000, Lord, 5,000 to the wife and 5,000 to the daughter.
Okay, and what are you doing?
Lord, I have been regularly paying, my Lord, since
No, you must be. What is your engagement?
Lord, I am the clerk, my Lord, in a primary health center at Aurangabad. From my bank itself,
That's
Lord, 10,000, my
so.
Lord.
You see, the amount, whatever be the quantum,
But my Lord, I have many
As per
liabilities, my Lord, that I have not disclosed. And my Lord, what is pinching me, my Lord, is para number 14 of the impugned judgment. It says that from the salary slip, it appears that into my home I take 22,530. But so far as liabilities are concerned, Lord, I have taken the loan. Lord, my mother is living with me. Lord, I have 2 daughters and 1 brother to see. Lord, I have just got my sister solemnized his marriage, her marriage, my Lord, 2 months before. All those liabilities, my Lord, I beg to bring on record by filing my affidavit.
no, we are not going to entertain the affidavit
No,
over here. Do
no.
you have a case that the wife also has an independent source of income?
Lord, I have said so.
Where have you said?
Lord, I have said so. Lord, in page number 23 itself. Lord, I have said that she used to work, but I have not seen her working. But she used to work. It is in the finding itself. Page number 23.
Whether any document has been filed or evidence has
No,
been
neither you have filed nor I have filed. And my Lord, I have been relying upon my Lord's decision that affidavit of disclosure is must.
Mr. Karnkar,
Yes, sir.
you see, on the basis of the judgment, you can go through it.
Well, let by
You file your wakalatnama tomorrow, we'll post it day after tomorrow. This matter has to be remanded back. Earlier the better. So far as the maintenance which has been fixed is concerned, I always take it as an interim maintenance subject to final outcome. I give 3 months time to the parties, to the court to conclude, and 1 month time to the parties to file the necessary disclosure in terms of the same judgment. You can have a look at this judgment.
If they are not saying that they have, the petitioner has not seen what she
No,
is
no.
doing.
You see, therefore
Without
the
evidence
you have not
and
seen
no
the judgment. You are arguing. You see the judgment because the parties are to I'm telling you one
Yes,
thing.
yes.
The take-home salary which he is saying of 22,000,
Yes.
the take-home amount varies from salary slip to salary slip. It is not the same in all the months, right? So therefore, there are certain procedure for disclosures and requirement has been laid down by the Honorable Supreme Court that will bring on record the true state of financial status of both the parties and the liabilities of both the parties and the responsibility. It says that even if the woman is earning, the husband is bound to maintain her.
Yes.
That aspect has also been considered by the court. So therefore, this disclosure was absolutely mandatory.
And
No
as well
court
as
can ignore.
minor daughter is also there.
That is, everything has been considered. But our court has not read this judgment and they have not complied with the order of the Honorable Supreme Court. I cannot ignore the judgment of the Honorable Supreme Court, right? Having not done so and being brought to our notice that it has not been done, we cannot ignore it. So the maintenance which has been fixed, that will be kept intact for some time. You have to bear it for 3-4 months.
I have been paying regularly.
He has been paying
And I
regularly.
will be paying.
As per my instruction, only 1.20 lakhs has been paid.
No, everything will be
21.
taken care of. Everything will be taken care of. It also says that the maintenance has to be fixed from the date of filing of the application. Everything has been taken care of. Okay.
I will
So you
go
file
through
your
that.
vakalatnama tomorrow. You
Yes.
can take it up day after tomorrow, and this is the order which I
If
am.
possible next week.
Next week you have seen next week. I have not seen tomorrow also.
Next Tuesday, my friend.
I don't know. I don't know. Whatever. Okay. Next Tuesday.
Next Tuesday.
Criminal Revision Number 584 of 2021. Learned counsel for the parties are present. The learned counsel for the petitioner, Mr. D.K. Kankar, appears on behalf of private opposite parties and has submitted that he shall file the vakalatnama by tomorrow.
Yes.
Counsel for the petitioner submits that the impugned order has been passed after the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha, reported in bracket 2021, bracket close 2 SCC 324, judgment dated 4th of November 2020.
But I have been also
But
relying my lord's order.
But the directions passed by the Honorable Supreme Court has not been complied, although it was clearly directed that the required affidavit of disclosure in terms of the state judgment was to be filed in all the pending proceedings. He submits that the matter is fit to be remanded for fresh consideration so far as the quantum of maintenance is concerned. As counsel for the state is present, pose this case for final disposal on next Monday. Monday?
Yes.
On Monday. LCR आ गया इसमें?
Item 16, WPS 51 of 2023.
Yes, petitioner.
There for area of salary.
Counter affidavit filed.
No, but they have not filed any counter.
Why have you not filed counter affidavit?
Lordship, since these matters are similarly situated to, as per the petitioner, similarly situated to the other paid managers, Lordship, it may pass me, Lordship.
My lord has
Should I record that you don't want to file a counter affidavit?
Lordship,
There is an order of filing counter affidavit.
Lordship, then I will seek instruction because they are claiming that they are the same. Earlier also, your Lordship had passed
one of the
several
order
orders, Lordship.
went up to the Supreme Court, my lord, has noted all this. And he expertly covered. Paid manager का है.
Any adverse order has been passed against
Yes,
you.
sir. That,
So
that-
therefore, without the counter, how do I set it aside?
because the same adverse order
We
has
do
been
not
passed and set aside.
WPS number, same order.
Same similar order only the
Similar
later-
and same are two different things.
But same and similar since
Same and similar.
may
You see, in one order, there are number of petitioners, number of persons.
but the content
Let them file the counter
as
affidavit.
it is.
WPS number 51 of 2023, in spite of order dated 16/1/2024, no counter affidavit has been filed so far. Counsel for the respondents are directed to comply the order by way of by way of last indulgence by 15th March, post on 19th March.
Lordship, at least 2 weeks.
By 1st April, by 1st April. Rejoinder, if any, by 10th April. Post on 15th April. Under the heading for final disposal. You also have to file your affidavit. File it.
Concerned respondent.
We do not know. It is for you to file it or not to file it. If you don't file it, we are not here to advise you to file a counter affidavit.
Item 17, WPS 300 of 2023.
The matter relates to caution of NC6, my lord. It is the order passed in pursuant to order of the Honorable High Court, my lord, by which claim of the petitioner for
Rejoinder to counter affidavit filed.
yes. It has been rejected on the ground that petitioner has not qualified the necessary examination as per the ACP scheme, my lord. So only on that point, my lord, I have filed the rejoinder stating that one resolution of the state government exempts the employee after attaining age of 50 years, my lord, to pass the examination. As this petitioner, my lord, has filed application for exemption that was not considered, my lord. And second point is that not in that period, my lord, no examination was held by the authority.
Where have you stated?
In rejoinder, my lord.
You have said so for the first time in rejoinder.
Yes.
You file a supplementary contract. They make out a case in rejoinder only. You can't help it. WPS
Lordship,
number.
may I mention one thing, Lordship? So far as this contention of concern, Lordship, there is one condition also, Lordship. When the petitioner file for exemption and thereafter once concerned officer required to give assent exemption upon it. Thereafter,
But if you sit over it, who will be responsible?
Lordship.
But he has made a statement that there was no departmental examination in the rejoinder. Where is it?
Yes, sir. In paragraph 6 of the rejoinder, my lord. At page 10 of the rejoinder, my lord.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that a rejoinder has been filed in the present case stating that no departmental examination was held during the period concerning the petitioner, and the petitioner had also filed an application seeking exemption from passing the departmental examination upon attaining 50 years of age.
Yes,
Counsel for the respondent submit that this aspect of the matter has been brought on record only through rejoinder. Counsel for the respondents is directed to seek instructions and file a supplementary counter affidavit with regard to the averments made in the rejoinder. And if any departmental examination was held, then the details of the such departmental examination we also mentioned in the supplementary counter affidavit. The supplementary counter affidavit should also reflect about the claim of the petitioner that he had filed an application seeking exemption and what was the result of such an application.
petitioner
us-
may be directed to serve copy of rejoinder, Lordship.
What is this?
it has been served.
Because maybe, Lordship.
It has been served, of course. No, just a moment. It has been served. You give him a copy.
Yes, ma'am.
You have a copy?
Yes, ma'am. That's all.
Let the supplementary counter affidavit be filed by 10th April.
Lordship.
You seek instructions on that. Supplementary rejoinder be filed by 26th April. Post this case on 30th April under the heading for final disposal.
Item 18, WPS 328 of 2023.
There was a direction for JPSC to file a supplementary counter affidavit. Probably requesting and praying for further 2 weeks time. There was on instruction now, we have got the oral instruction that the university, the JPSC has received some letters from the university. We are considering, and before that I will filing this.
WPS number 328 of 2023. Counsel for the parties are present. Counsel for the respondent JPSC.
JPSC.
Prays for and is granted time till 15th
15th
March.
Lordship, if possible on 20th March.
होली के पहले कुछ नहीं कर सकते आप इनके लिए.
नहीं कर सकते हो.
He should feel happy in Holi.
I hope.
By 15th of March, 2024. By way of last indulgence, pose this case on 19th of March under the heading of final disposal.
So far, one part
It
is
could
considered.
become infructuous.
No. Usme there are two-fold prayers. So far, one-fold prayer is regarding the concurrence. Previously, the JPSC had already rejected it. Now, upon a decision taken by the commission, we are reconsidering it. The first decision was regarding his concurrence. Thereafter, a proposal has to come from the university. Then the matter of promotion will be considered. It will take time, Your Lordship.
This will take time, but at least you can say
I-
that it is under active
Active
consideration.
consideration, yes. Right now
Once it is
under
there,
active
then the writ petition can be disposed
Yes,
of
it
in
can
those
be.
lines.
Your Lordship.
And then we can provide the timeline, isn't it?
Item 19 WPS 448 of 2023.
In this case, there was a direction to file counter affidavit on behalf of the interveners minority.
So,
I am seeking 2 weeks as a last interveners minority. In this case, to file the counter affidavit on behalf of the respondents number 7 to 56 who have been included as who were the interveners minority.
how much time do you need?
2 weeks. Also, my lords, there is one request, my lords. Since, my lord, in the prayer portion, prayer has been made specifically with regard to respondent number 5 and 6, my lords. So, my lords, they have not been noticed, my lords. We have received wakalatnama on behalf of respondent number 5 and 6 as well, my lords.
You have received wakalatnama?
My lords, we have received,
Fine it.
my lords, but the
Registry is not accepting
no, my
it.
lords, they are saying that until and unless you have been noticed, they will not accept the wakalatama.
5 and 6.
My lords.
WPS number 448 of 2023. The learned counsel for the parties are present. The learned counsel appearing on behalf of the intervener has submitted that he has received wakalatnama on behalf of respondent number 5 and 6 also. But in absence of any order passed by this court, the registry is not accepting the wakalatnama. Considering the submissions, the registry is directed to accept the wakalatnama if filed on behalf of respondent number 5 and 6 also. At this, counsel for the intervener submits that he shall file a consolidated counter affidavit on behalf of the interveners as well as private respondent number 5 and 6, for which he prays for how much time? Prays for and is granted time till 21st March 2024 to file a counter affidavit. State has filed counter affidavit. Okay. You serve him the copy. On the next day he will ask for the copy. So you better serve. The rejoinder, if any, by 25th April, post on 30th April.
Item 20 WPL 840 of 2023.
In this case, the petitioner has prayed for quashing of the elixir.
In this counter will be required. This is the first time it has come.
No order to file counter affidavit.
And I would say, I would also pray your lordship that perhaps your lordship could send for the lower court records.
In fact, lordship, page annexure 8, page 64 may be seen that petitioner has earlier moved before this honorable court, and the matter was remanded back to the learned PO Jamshedpur for considering it afresh, lordship, and thereafter they have passed an order. That is contained in annexure 9, page 89.
What is it that is disturbing you?
Yes, lordship.
What is it that is troubling you in the order? The case, the claim has been rejected fully.
Claim has been rejected.
On what ground?
On ground that's it. Page 112, lordship, may be seen.
Yes.
My award is that termination of service or service so and so is proper, and these workmen are not entitled to get any relief.
In fact, Lordship, in the first reference case, they have said that the reference is not maintainable. Now, in this order, they have said the reference is maintainable, but they are not entitled for any leave.
You were discharged from service or you were dismissed?
In fact, they said that we have been retrenched from the service.
25F.
25 is attractive.
And you say that the procedure was not followed.
Not followed.
So what is the consequence?
Consequence, Lordship, there are two consequences. Either reinstatement, but since we have attained the age of superannuation, so the Honorable Supreme Court has also said that in case of retrenchment, 25F is not followed, then compensation may be determined. So, Lordship, I am making a humble submission to let them file a counter affidavit. LCR may be called for a date.
No, why do you need? You want compensation?
No, my lord, it's not that simple. They have failed to prove 240 days. They were not permanent employees. Okay. It's not as a 25.
If they have failed to prove 240 days, then 25F is not attractive.
Not
yes,
attracted. That is the finding of
Where
the
is the finding?
Pa-
And what is
paragraph
the
17.
perversity in that finding?
Page 106, your lordship. Paragraph 17.
One 106.
No, that is the finding part. What he is saying. Here the onus lies upon
Here the onus lies upon the workman to prove the fact that they come to the purview of provision of section 25 of the ID, but applicant have failed to prove the fact that they were in continuous employment for a period of 240 days in a period of 12 months immediately preceding the date of their alleged final termination. The workmen in the present case have not produced any cogent and convincing documentary evidence to establish their continuous service for not less than 240 days in preceding 12 months for the alleged final termination. Therefore, mere deposition in absence of any documentary evidence of the concerned workman is not sufficient to hold that termination from service was violation of section 25 of the IDA. And Lordship may see the management has not adduced any witnesses. Management has not adduced any witnesses.
You
Rather,
come to page 103. 103. Your evidence has been discussed. Can you read it? AW1.
yes, Lord, I am reading. AW1 has stated that all the workmen were appointed in the year 1970.
How many workmen are there?
In fact, in this case, 4 workmen have filed this petition.
That's true.
Earlier, there was the fact of the case.
No, can you read this?
AW1 has stated that all the workmen were appointed in the year 1970. There was intermediate gap of 2-3 days in a year. The workmen were made to cease from 13th March 78 to 9/4/78, from 17/4/78 to 21/5/78, lastly on 9/8/78. He has further stated those who have worked more than 240 days in the last preceding 1 year before termination. No retrenchment.
What is the date of termination?
इन लोगों को आउट कर दिया गया.
What is the date of termination? According to you?
Date of termination, page 93 may be seen.
You just give the date.
27/8/78 for petitioner number 1. For petitioner number 2, 13/8/78.
Then?
And for petitioner number 3, serial number 5 में है 9/8/78. And they were appointed in the year 1970. Para 3/1 में है. Three petitions are there also that I have stated. And page 94 may be seen, Lordship. Page 94. From bottom, Lordship, 7th line, it is stated that the termination of service was done by verbal order of Superintendent Parks and Garden, who had no authority to terminate the services of the workman. The workmen firmly assert that they had committed no misconduct so as to invite any penal action, and they had honestly, sincerely, loyalty, devotion served the company for a period of 9 years. Continued except for a small break.
The learned counsel for the parties are present. The learned counsel for the sole respondent is directed to seek instruction and file a counter affidavit in the present case. The petitioners have already attained the age of superannuation. It is submitted that the petitioners have already attained the age of superannuation, and the matter relates to non-compliance of Section 25, capital F of Industrial Disputes Act. The counsel for the parties have submitted that the records from the concerned court be called for. The counsel for the petitioner has also submitted that the petitioner still would be entitled for compensation in terms of the various judgments passed by the Honorable Supreme Court on account of non-compliance of provision of Section 25 capital. Call for the records from the learned court concerned.
Reference case number 20, Lordship, of 1994.
Reference case number 20 of 1994.
Labor Court.
They will give the detail. Admit, rule returnable after 6 months. सिक्स मंथ्स के बाद का डेट दे दीजिए. मार्च, अप्रैल, मई, जून.
For finding required, let there be a time fixed.
17th October.
17th
October.
For filing counter affidavit, let date the time may be.
Counter affidavit will actually have no value.
It will mainly be.
Isn't it? It will be based on the materials on record.
Item 21, Salupius 904 of 2023.
In this case, the rejoinder is ready, Your Lordship. Rejoinder is ready. It may be tomorrow, Your Lordship.
What is the matter?
Matter is related with the compassionate appointment. In this case, during the
What is the date of death?
date of death. Yeah, this one is the exceptional case, Your Lordship. In 2004, Your Lordship, the employee who became missing till then, since she has been approaching to the concerned respondent, but they didn't consider her case.
Do you have a declaration by civil court?
Huh?
Do you have a declaration by civil court?
Yes, and
When?
Subsequently, I
When
filed
did you get
in
the
2020.
In 2020.
In 2020.
You are the son of the
I am a
deceased?
wife.
Wife.
And thereafter, entire benefit has been given to me, but only the compassionate part. Thereafter, subsequently, it is the second round of litigation. In the first round, after the first round of litigation, by the honorable court order, after 20 years, she has, the concerned respondent has given me the entire benefit. Only on the compassionate appointment, they are considering the scheme of 2018. My case is that as on date, as on application, when I died, the scheme would be applicable. The scheme of 1998.
What is the date of death?
2004.
No. The date will be relatable to the date of declaration.
Declaration.
When was the declaration done?
2020. तो 2020 में उनका किया है, but they have also violated. मैं एक सर्कुलर मिला है कि लापता के लिए 1 महीना 1 साल तक का एक सर्कुलर है, इसको कल मॉर्निंग में रख दिया जाए. आई हैव ऑलरेडी और इसको रिसीव कर दिया, इसको एक्सेप्ट आज कर देते हैं, कल मॉर्निंग में इसको इसमें सारा हम सर्कुलर भी लगा देंगे सारा. इट में भी
Copy. सर्कुलर जब आप लगाते हैं तो रेस्पोंडेंट को देखने का जरूरत नहीं है. रीट में क्यों नहीं लगाते हैं अपने सर्कुलर्स? You bring something for the first time in rejoinder and you don't want them to go through it and you will start your entire argument from the rejoinder.
नहीं रिजॉइंडर नहीं, वो तो काउंटर एफिडेविट फाइल किया उनका जवाब दे. काउंटर एफिडेविट में दे हैव टेकन टू जस्ट काउंटर एफिडेविट दे हैव टेकन टू प्ली कि 2018 लॉ विल बी एप्लीकेबल इन माय केस कि जो 2018 का है at that point of the 1998 का लॉ एप्लीकेबल हुआ. दैट इज इट.
Let's see.
I just need that today I'll get the rejoinder.
You will get it right away.
अभी जस्ट बीटिंग
अभी कोई 2 मिनट के अंदर.
2 मिनट.
Council for the parties.
Monday रख दिया जाए तो बेटर होगा.
तो माइंड मेकअप करनी है. मंडे को फिर से पढ़ना पड़ेगा. अच्छा कल देखते हैं. राइट.
इसको रिसीव इसको आज फाइल.
So far as the compassionate appointment, your ladyship is concerned with the non-matric.
हाँ यही
educational qualification only for that.
Old law के अंतर्गत हमारा
it has been considered for earlier, but for
now consider the suffering of this lady.
She is getting all her.
Considering the suffering of this lady, कि कितना वो suffer
When was the new when did new circular come into force?
2015.
About matric.
Matric. 1/12/2015.
And where is the decree?
Decree is of.
Where is the decree?
Decree is of. Uh, 2020, 23rd March 2020. Ultimately, I had to go. इन्होंने कंसिडर नहीं किया. देर आफ्टर हम हाई कोर्ट में भी किए थे, सारा चीज किए थे, बट दे डिडंट कंसिडर माय केस.
I will go through the rejoinder, your ladyship.
मंडे को ही रखते हैं. थोड़ा काम करना पड़ेगा. आप लोग तो करेंगे नहीं करेंगे ना?
Synopsis.
We will comply, your lordship.
पढ़ते लिखते भी नहीं. ऐसा कौन सा चीज है जो हम लोगों को मिल जाता है, आप लोगों को नहीं मिल सकता? हम लोग के पास टाइम बहुत होता है. हम लोग के पास कोई काम हम तो है नहीं. आप लोग के पास बहुत मल्टीपल काम रहता है. Don't expect that we have team to do our research work. No. In Jharkhand High Court, we have to do everything ourselves. You have team to do research work. We don't. We don't have any support to do it. But still you are not able to do it. Is there any circular of state government which deprives a person of compassionate appointment on account of civil death? In one case I have seen, I don't know, maybe in the case of one company, depriving compassionate appointment on account of civil death. Your state has got a circular. Coal companies cannot have, because their employees, they disappear in the mines. And their body is not found at times. Very difficult. I think state government has a circular. Figure it out. Try to find out by Monday. I have dictated any portion of the order. Counsel for the parties are present. Rejoinder filed on behalf of the petitioner during court proceedings is taken on record. The At the joint request of the counsel for the parties, post this case under the heading for final disposal on Monday. Monday कितना केस है आप बताए थे?
Okay.
4 केस है. चलिए, इसको parties to file short list of dates and synopsis of argument. You get it ready, file it during the post proceedings, both of you. Find out about that circular. I have seen one circular. I don't remember in case of state or some other company. I don't remember exactly. There are certain judgments also on account of civil death. Rather, we have passed judgment that in case of civil death, you cannot deny. There are judgments to that effect also. It is for the petitioner. I do not know whether you will be able to raise.
एक केस है इमेंट टू वोट.
कौन सा? कब?
नहीं सिविल डेथ पे.
सिविल डेथ का एक मैटर है, बताइए जरा नंबर.
2938 of 2020.
2938 of 2020 डिस्पोजल डेट. ये है हमने डिसाइड किया. हमने डिसाइड देख लिया. आप लोग को कुछ लीगल एड में जमा करना चाहिए. कोर्ट से असिस्टेंस मिल रहा है, रिवर्स ऑर्डर में चल रहा है.
We are deeply organized कि हम लोग को ये मिल पा रहा है गाइडेंस.
आप लोगों को पता नहीं हम लोगों ने क्या किया. We have put all our judgments in Google Drive, which is available at any point of time. पूरा हाई कोर्ट का तो नहीं, लेकिन जो मेरा जजमेंट है, we are just putting it in Google Drive, and any time it is available. So you don't use technology, no? If you will not use technology, you will be the previous generation. इस जनरेशन में रहना है तो टेक्नोलॉजी यूज करना ही पड़ेगा. It is so easy. Some idea. Google Drive में डालिए और सारा अपना जजमेंट्स अपने हाथ में रखिए. चलिए.
Item 22, Chalu PS 1192 of 2023.
Payment of gratuity 10 to 20 lakhs. According to their admissibility.
Find your counter.
Yes.
Pleadings complete.
They have not filed any rejoinder.
You want to file any rejoinder or you are ready?
But so far the counter I have gone through. They have only said.
No, we are not concerned. If you want to file your rejoinder, I will adjourn it. But in the midst of the proceedings, I will not adjourn.
It will not require.
Okay. So what is the matter? You just formulate the point.
For payment of gratuity, 10 to 20 lakhs, that is according to the admissibility of each of the petitioners.
How many petitioners are there?
26.
26 petitioners in one writ petition.
Not so. Only one issue is there, madam. Same issue. On the basis of this annexure 1/3, they all have retired within that period, madam.
Annexure 1/3.
1/3 is the document, madam.
Okay. This is clarificatory letter.
Yes. For payment of this gratuity.
Can you read it?
Yes, sir. Payment of gratuity, this is from the ministry itself, to the all companies.
Read it.
Payment of gratuity to the employees of CPSC clarification regarding the undersigned is directed to refer to DP Oman such and such dated 3/8/2017, which inter alia stipulates the increase of ceiling gratuity from 10 lakhs to 20 lakhs with effect from 1/1/2017 for executives and non-union supervisors of CPSC on IDA pattern of pay and DPA such and such dated 11/4/2018, informing about the amendment in the Payment of Gratuity Act 1972 regarding enhancement of ceiling of gratuity from 10 lakhs to 20 lakhs and effective date is 2008. These departments received various representations from different stakeholders seeking clarification on the effective date of enhancement of ceiling of gratuity. Accordingly, the issue has been considered and clarified as follows. The payment of gratuity under DPE guidelines dated 3/8/2017 is subject to affordability of CPSEs concerned effective for the period from 1/1/2017 till 28/3/2018 in respect of executive and non-unionized supervisors of CPSEs on idea pattern where pay has been revised with effect from 1/1/2017. Whereas on and after 29/3/2018 the payment of gratuity of rupees 20 lakhs is mandatory for all the CPSE and their affordability as it is a statutory provision in the light of the amendment in the payment of gratuity of 1979. This provision is applicable to all employees of all CPSE. Further, the government decision on the basis of recommendations of the 7th Central Pay Commission regarding raising the gratuity ceiling from 10 lakhs to 20 lakhs is not applicable to the employees of
What is your date of superannuation?
1/1/17. I have.
It is between 1/1/17 or prior to 1/1/17?
This is.
What is your date of superannuation? And where have you stated so in the writ petition?
Yes, para 6. Para 6.
Para 6.
All are in 2017. In different.
Para 6 does not give the date. Date
Yes.
is retired on such and such.
Yes. Jagannath Bhagat retired on 31/5/2017. Next on Bharat Lal Ram 31/12/2017.
It falls between. His date of retirement falls between 1/1/2017
to 29/3/2018.
to 29/3/2018, right? So it will depend upon their affordability and the conditions as per clause 2A.
There is one more thing. This circular applies to, I'll just tell his case, applies to executives and non-unionized supervisors.
Yes.
We are not.
They are the wage board employees. Means
So they are not covered under this.
They are not covered under both the terms. They say that when unionized and non-unionized could get it from 1/1/17, why should we be deprived? They are guided by
It's essentially a
NCAA.
matter of policy.
That is not in the counter.
Look, you have
What
to make
am I
out your
learning?
own case, isn't it?
Yes, Lord.
Yes. Are you covered by this circular or you are not covered
I am
by this?
covered by this.
Okay, so you are.
For that they also.
Just a moment. So you fall under executive category?
No.
Okay, you fall under this.
Non-unionized supervisors.
You fall under this?
This.
From where have you stated? Where have you stated so in your writ petition that you fall under this category? Where have you stated in your writ petition that your appointment was or your continuation in service was under non-unionized supervisor?
That I have not stated categorically.
Then you have not stated.
My
Who
lord,
can
they-
help you?
What, my lord? They have stated in their counter affidavit that or because executives have been paid on the basis of affordability, my lord. And now in the counter they say.
Mr. Mehto, just a second. On the face of it, you have not stated specifically that you fall under this category, right?
Yes.
Now, whether you fall under this category or not will be essentially a matter of consideration by the respondent at best,
Lord.
right?
Lord.
They'll consider it.
Lord.
You consider it.
And
we have specifically stated, Your Lordships.
Where is it?
Kindly say, we have stated that two persons made a representation, we rejected it also.
Where is that?
Lordship, para 6 onwards, Lordship, kindly say. We have explained everything. My counter affidavit, para 6 onwards.
This
It
can
is
you read?
stated that yes, 11th April 2018, an office memorandum was issued by Department of Public Enterprises, Government of India, in which it was stated that payment of gratuity under the Payment of Gratuity Act has been amended by Payment of Gratuity Amendment Act 12 of 2018, notification dated 29/3/18, published in Gazette of India, in pursuance to which central government specifies that amount of gratuity payable to an employee under the act shall not exceed 20 lakhs. That on 8th January, August 2018, by memorandum number such and such, office memo issued by General Manager PC CIL Kolkata to pay revision of board level and below board level executives of say Coal India and their subsidiaries with effect from 1/1/17, who were, so I has been is a typing mistake, WHO, who were on roll of the company as on 31/12/2016. In the said memorandum, it was pointed, the point number 912, it clearly mentioned the ceiling of gratuity of the executives and non-executive supervisors will be raised from 10 lakhs to 20 lakhs with effect from 1/1/17. It is stated that by letter number 1703, dated 22/6/19, issued by the General Manager PNIR Headquarters Ranchi, the area-wise list and amount payable of difference if the gratuity limit is raised to 20 lakhs to all non-executives of the area were asked from the decision to make standardization committee for JVCCI 10 with respect to wage board employees who had retired between 1/1/17 to 23/9/17, which were subsequently provided by the area. That till date, no provision or office manual to release difference of gratuity with respect to wage board employees has been communicated by the headquarters of Coal India. It is stated that management on receipt of the representation from all the representation joint signatures, payment of gratuity from 1/1/17 to Satna on examination same was suitably replied by the management of Rajapur that as well as two of the petitioners have been informed in writing. Data that has been acknowledged and that has been annexed here also, that is Annex C and C by 1 if you have
Where is wage board employee mentioned?
Yes.
Where they must have mentioned that they are working as wage board employee.
But they have not said they doesn't come. They do not come under this non-supervisor. They have not said. Rather, they have said we have sent.
You have also not said that
it is
you are covered by this particular circular. Because you come within the executive category and this particular.
My lord, we have said we should come under this non.
No, they have claimed parity with unionized and non-executive or non.
And these letters says, my lord, that कोल इंडिया से दिनांक इतना के बीच सेवानिवृत्त हुए कर्मचारियों के उपादान की राशि का डिफरेंस अमाउंट के कर्मचारी करने के लिए अभी कोई भी निर्देश प्राप्त नहीं हुआ है। मुख्यालय से निर्देश आने के पश्चात ही भुगतान किया जाएगा। This is the information. It is not that rejected or we are not entitled. मुख्यालय से हेड ऑफिस से आएगा तो वो आया नहीं। मतलब the chairman should answer Coal India, respond number 1, or he may be directed to consider. If you come under this zone, so should be given. Executives have been paid, my lord. It is admitted. I have also annexed 2 documents. And so far representation is concerned, I have annexed that document. They have represented. All have joined.
Where is your representation?
Annex 3, 25 page.
Due to be paid to non-executives. This Annex 3 is with regard to executives.
Annex 3, they are claiming parity with the executives.
We are not claiming parity. Rather, we are saying that they have been paid. So far affordability is concerned, because they say that affordability was there for executives and not for these people. This petition.
So at least you are not executive. That is fine.
Yes, that is.
And you are not sure whether you are, since it is not your case that you are covered by this circular, it is not your case that you are covered by this circular.
Though I have not stated categorically that we come under that norm.
You can have either of the two. Either you say that you are covered by Annexure 3,
Yes.
or you say that you are not covered by Annexure 3, your matter is pending before one or the other authority for consideration.
We are covered
You can't
by-
have both,
No,
isn't it?
my lord,
If
covered
you
by
say
Annexure
that you are
3,
covered by this, then
1
I
by
will
3,
record.
as my lord, non-executive. That is
Non-unionized.
non-unionized.
If you don't get your wages as per NCWA.
Non-unionized supervisors.
So you are, according to you, I will record it. You see, this may be difficult for you to at a later stage. I'm just indicating.
Because if you
Then I
change
will
their
say,
post,
yes.
there is someone has retired as foreman, some are crane operator. How can they be non-unionized executives? They are workmen.
No, we come under this
Verify कर
may be.
लीजिए यहाँ से फिर आपका तरफ से.
आपका तो कोई statement ही नहीं है. There is no statement.
Then I shall give you a statement.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioners has submitted that all the petitioners have attained the age of superannuation during the period from 1/1/2017 to 29/3/2018. He further submits that White Office Memorandum dated 10th July 2018, issued by the Government of India, Ministry of Heavy Industries and Public Enterprises, Department of Public Enterprises. Certain directions were issued with regard to payment of gratuity to employees of Central Public Service Enterprises. The learned counsel has submitted that as per clause 2 within bracket A, the council has submitted that the petitioners are covered by clause 2 within bracket A of the said circular. Correct, Mr. Mehta? But the petitioners are not being given the gratuity in terms of the said office memorandum dated 10th July 2018. He submits that a representation has also been filed by the Annexure 3, but no decision has been taken. The learned counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that the petitioners are not covered by clause 2 within bracket A, and as per the representation as contained in Annexure 3, the petitioners had raised a grievance for payment of arrears of gratuity, rupees 10 lakhs, rupees 20 lakhs minus rupees 10 lakhs to the non-executives. The learned counsel submits that as per the said circular, executives and ununionized supervisors, non-unionized supervisor of Central Public
Sector
enterprises are covered, and the petitioners fall under the category of workmen.
Unionized.
And therefore they fall under unionized cadre. Unionized category. And they are members of labor union.
Their wage is guided by national coal wage agreement.
And their wage is governed by national coal wage agreement. The learned counsel has submitted that as per the counter affidavit, the no directives in connection with the persons like the petitioners has been received from their headquarter, and therefore the certain communications have also been issued to the workmen, stating that in absence of any directives from Coal India Limited, Coal India Limited will give the directives.
Yes, but two things are there. I'll just as a concept under workman compensation payment of wages act, whatever ceiling is given, it is binding upon an employer. However, clause section 5(4) says that employer may give a better by way of contract
That's
or
it.
agreement or policy.
But in
So he is
the instructions will come from where? Coal
from
India
Coal India
Limited.
Limited. It is over and above the payment of gratuity.
That's right. No instructions have been received from Coal India Limited with regard to any further payment
Yes.
to the petitioners.
So there is no
After hearing the learned counsel for the parties and considering the materials on record, this court finds that in the writ petition there is no averment as to whether the petitioner is covered, petitioners are covered under clause 2 within bracket A of the office memorandum dated 10th of July 2018. Admittedly, the petitioners do not fall under executive category, and by virtue of representation as contained in Annexure 3, it appears that the petitioners were claiming relief under non-executive category. However, it is still not clear as to whether the petitioners would fall under non-unionized supervisors as mentioned in clause 2 within bracket A. From the perusal of counter affidavit, it appears that the matter has been referred to,
No, we have sought
no
whether there
reference.
is any. We have only sought for that whether there is any policy decision. With
Okay.
respect to
From the perusal of the counter affidavit, it appears that a letter dated
ये थोड़ा ये लाइन दो लाइन है पढ़ देते हैं ऐसा बात
एक
नहीं।
सेकंड प्लीज।
आपके पत्रांक के द्वारा के माध्यम से महाप्रबंधक के कार्यालय उपरोक्त विषय से संबंधित आवेदन दिया था, जिसके संबंध में यह कहना है कि कोल इंडिया से दिनांक इतना से इतना के बीच सेवानिवृत्त हुए कर्मचारियों के उपादान की राशि का डिफरेंस अमाउंट के भुगतान करने के लिए अभी कोई भी निर्देश प्राप्त नहीं हुआ है।
From the
भुगतान के लिए
sir,
निर्देश
please hold on. एक तो आपका ऐसा वेग रिट पिटीशन फाइल किए इतना लोगों को लेकर कुछ कहने का नहीं। Basic foundational pleading is totally absent in your writ petition. We are trying to figure out to give you some relief if you are otherwise entitled. Please hold on for some time. From the perusal of the counter affidavit, it appears that representation was filed by the petitioners under joint signature for payment of difference of gratuity for the period from 1/1/2017 to 29/3/2018, and some of the petitioners were informed by letter dated 11/1/2023 that no instructions have been received regarding such payment to the persons like the petitioner. However, from the perusal of the records, it appears that there is an element of uncertainty with regard to the claim of the petitioner, and such uncertainty is first required to be clarified by taking a decision as to whether the petitioners would be covered by the circular covered by clause 2 within bracket A of the office memorandum dated 10th of July 2018 as contained in annexure 1/3 of the writ petition, and if they are covered, if they are found to be covered by that circular, there is no reason for not making payment in terms of the said circular. However, if the petitioners are not covered by that circular, then also clarity is required to be there with regard to their entitlement on payment of gratuity. The fact remains that the executives and inverted comma non-unionized supervisors have been held to be entitled as per the office memorandum dated 10th of July 2018.
Lordship only say if they are covered by non-unionized supervisor or executive, then only they will get. Because NCWA, it is a tripartite agreement.
That's right.
Neither can I take a decision to give either on the basis of the amendment in Gratuity Act they will get, or on the basis of any.
It is further not no, and if the petitioners are governed by any wage agreement, the impact of such agreement is also required to be considered with regard to the entitlement or otherwise of the petitioner. कोल इंडिया के पास भेज के क्या होगा?
कोल इंडिया नहीं, हम लोग को फैक्चुअली तो हम ही लोग को डिसाइड करना है.
Yes, CMD will take a call regarding your entitlement.
He is the general manager because he has the record. Otherwise, general manager.
General manager, respond number 4. No, it will govern everybody. All the collieries will be governed by this.
No, policy decision we cannot take.
No,
that
but
has to be taken by the government.
No, but
we have to see whether they are covered under unionized or non-unionized, and they are not executives admittedly. So that has to be seen from the service records only. It is a fact finding here,
Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 4 by filing a detailed representation along with a copy of the writ record. The representation should clearly indicate the nature of employment of each and every petitioner, so as to enable the respondent number 4 to decide as to whether the one or the other petitioner fall within the category of clause 2 within bracket A of the office memorandum dated 10th of July 2018. If one or the other petitioner falls upon such representation, the respondent number 4 is directed to pass a reasoned order within a period of 4 months from the date of such representation upon verification of the record, and if one or the other petitioners are found entitled in terms of clause 2 within bracket A of the office memorandum dated 10th of July 2018, appropriate follow-up orders be passed so that the monetary benefit arising out of the same is remitted to the concerned persons. In case the reasoned order be communicated to each of the petitioners through speed post. You want hearing also?
Yes.
The reasoned order is required to be passed after granting an opportunity of hearing to one representative of the petitioners. One representative.
In the representation, they will give the address. Otherwise, we may not be having.
They will. Speed post चाहिए तो address देना पड़ेगा ना. Speed post at the address to be provided in the representation itself. It's a policy of the central government. Very difficult. Not easy. Central government is not even a party in these proceedings.
Item 23 WPS 1614 of 2023.
Petitioner.
Sought for suit.
Next.
Item 24, WPS 2681 of 2023.
Also, the petition is paying to the first and the second MSCP. He is in the continuous service since 23 years. On the last occasion, Lordship, the Honorable Court has directed to file a supplementary affidavit stating in what district the present petitioner is working and when the service of the petitioner is transferred to the state of Jharkhand. That I have filed in my supplementary affidavit, Your Lordship. Leadership will kindly see para 5 of the supplementary affidavit.
Leadership, in this matter, state of Bihar is also a necessary party because petitioner was appointed in the undivided state of Bihar and then subsequently in 2009 he was transferred to the state of Jharkhand.
So,
The
for
grant,
ACP you need state of Bihar.
he was appointed. Whether or not any departmental examinations were conducted for that. Because he is claiming benefits of ACP and MECP. First and second MECP.
The learned counsel for the parties are present. Counsel for the respondent submit that the state of Bihar is an SCD party in the present case. As the petitioner was initially appointed in undivided state of Bihar, petitioner is directed to impede the state of Bihar as respondent number 4 in the present case in red ink during the course of the day. The counsel for the petitioner is directed to serve 2 copies of the entire records of this case to Mr. Vineet Chandra, who normally appears, who is a retained advocate of state of Bihar. By day after tomorrow, you will serve the copy. By day after tomorrow. Let a counter affidavit be filed by the state of Bihar as well as the state of Jharkhand, other respondents by 1st April. By 1st April 2024, rejoinder if any by 16th April, post on 23rd April under the heading of final dismissal. Next.
Item 25, WPS 3197 of 2023.
Seeking 1 week time. The pleadings are complete, Your Lordship. It's a dismissal matter. The appeal has also been dismissed.
You want what? You are seeking time?
Yes, Your Lordship.
The learned counsel for the petitioners parties are present. The counsel for the petitioner has submitted that you have been convicted.
Yes.
Under POXO?
No.
Yes.
It that was the informant who has made a complaint. His brother-in-law was convicted under POXO.
You have been convicted under which section?
PC Act.
When?
That I have to seek instruction because on that basis only this departmental proceeding was initiated.
Sure. You have to seek instruction.
There was a trap case, Your Lordship. On
Conviction is sustained.
Conviction that I have not taken instruction.
You don't have any instruction on any relevant fact. Avoiding a question, does it serve your purpose? Then your file, the pleadings are complete and you do not know.
Conviction is there.
Where is it mentioned?
Conviction is there.
Has the petitioner been convicted?
Yes. He has been found guilty. Page number 85 of my counter affidavit. Last paragraph.
Found guilty in the criminal case.
Also.
Where is it? What is the case number? Page number 84 of the counter affidavit. Yes, it is there. Where is the order of conviction? पिटिशनर ने क्या बोला है? नहीं बताने कोर्ट में. फिर ट्रैप केस में कन्विक्शन हुआ, यू डू नॉट नो अबाउट इट.
Annexure M Lordship.
It is a departmental proceeding order. Where is the order of conviction? What is the case number? What is the date of conviction?
CCB PS case number 1 of 2020.
ACP
PS case number 1 of 2020.
1 of
2020.
pending, disposed of. What is the date of judgment and which court is that? Your allegation is that you have helped a person who has been charged
For weakening
for
the
POCSO.
case. For weakening the case.
Yes.
Now my specific case is that when the bribe was demanded, Your Lordship, before that only he was convicted.
We do not. Bribe can be deferred also. There is a
That is-
deferred payment of contract, you know. You can have a deferred payment of consideration.
Trap case, same day, Your
You do
Lordship.
not know. In trap case, you were caught red-handed with bribe money.
Yes.
So the entire onus is on you to explain. He was returning you the loan. What defense did you take?
We took the defense that the very basis I have stated in my reply, Your Lordship.
We are not concerned with that. You have been convicted. Now you file the order of conviction.
I will file that, Your Lordship. The state, if he has been convicted, I will file, Your Lordship. As well as if he has not been convicted, the stage of the
The
case.
learned counsel, listening
Stage
counsel,
of the case.
the learned counsel for the state is directed to seek instructions and file a supplementary counter affidavit in the present case, stating the final result of the ACB PS case number 1 of 2020, which according to the petitioner is a trap case in which the petitioner was an accused. Convicted? Not convicted. Counsel for the petitioner is not aware as to whether the
Because
petitioner
the
has
proper
been
proper instruction
convicted
has
or not. एक हफ्ता में फाइल करिए इसमें. क्या करते हैं आप लोग? कन्विक्शन का ऑर्डर नहीं लगाते. Yes? Who will file this affidavit? I'll just ask some higher authority to file it. कौन फाइल किए हैं अभी? Respondent number 1 should file the affidavit. The counter affidavit has been filed, but there is no clarity with regard to conviction of the petitioner. This court is of the view that the aforesaid fact is an important fact which has neither been disclosed by the petitioner nor by the respondents in their counter affidavit. Let the supplementary counter affidavit be filed by respondent number 1. The supplementary counter affidavit be filed by 20th, 20 तारीख फाइल कर दीजिए. By 19th, post on 20th.
Passport matter 6 for 3.
Yes, where is that? आज मैं वो फाइल मॉनिटर फाइल्स कॉल कर लीजिए.
Passover case item 6 WPS 2606 of 2023.
Where is the council? कल के लिए. He's absent. Who's tomorrow?
Item 26 WPS 3271 of 2024.
Coalition on behalf of the arguing council, I was praying for a not today due to some personal difficulty, perhaps a medical emergency or I was praying that it may come up any day in the next week if possible. Maybe Monday or it should be possible.
Council for the parties are present. ये flag दीजिए. On account of personal difficulty of the arguing council, namely
Mr. Vipul Poddar.
Mr. Vipul
Poddar.
Vipul Poddar. A prayer for adjournment has been made. Let this matter come up on next Tuesday.
Item 27 WPS 342 of 2023.
Yes, petitioner.
Your Lordship, there was a direction upon the respondents to file counter affidavit. Counter affidavit has been filed by the respondent number 8 and 10. The respondent number 10 is Maulana Azad College, Your Lordship, supporting my case. Though the counter affidavit has been filed by the Jharkhand Academic Council, Your Lordship is totally misleading to the court, Your Lordship. Without verifying my document, the same report has been given to the Your Lordship, either we got the authority who had taken the decision against me, Your Lordship, and in the counter affidavit as well, Your Lordship.
For JPC, I have received the instruction. And whatever document they have annexed in the writ petition, we are relying upon that. The report that was sent by them was upon the verification of his intermediate certificate. The academic council reported that the roll code and roll number which has been given by him in his original certificate pertains to different person. This is the annexure 2 at page 21. This is the whole crux of the issue, Millers. Till date, it has not been rectified by anybody. Millers, academic council is sticking to it. It's page 21, annexure 2. This.
Where is your original certificate?
I have annexed it.
Where is it?
Yes. Annexure 4C.
Annexure?
4C.
There must be one certificate, no?
No, Your Lordship. I have enclosed even tabulation register, my Your Lordship's name entered in the register of the college, Your Lordship. Provisional certificate that has been issued by the Jharkhand Academic Council, Your Lordship, that has been obtained by the petitioner from the college itself. Annexure 4C. And college has, and Your Lordship, Maulana Azad College has specifically asserted, Your Lordship, that the document belongs to me. झारखंड एकेडमिक काउंसिल में इसमें क्या हुआ है कि झारखंड एकेडमिक काउंसिल में सेम रोल कोड से 2 नाम का एंट्री कर दिया गया है और एक वैसे व्यक्ति का नाम एंट्री कर दिया गया है जो मौलाना आजाद कॉलेज का स्टूडेंट है ही नहीं. स्टूडेंट हम हैं. जब मेरा डॉक्यूमेंट वेरिफिकेशन होने जाता है तो उनके नाम से वेरीफाई होकर किया जाता है कि ये गलत है.
Annexure 4 series.
Yes, sir.
Page number, please.
Page. Your Lordship, page number 25.
This is your admit card.
25, serial number 324. It's college register. My name is appearing there.
In whose name this is being shown?
One Saroj.
This Kachu Orao, that is being shown in Saroj Kumari Singh. Page 21, Lordship, may kindly have pleasure.
Page number?
Page 21, the writ petition. This is the report submitted by the sent upon verification request by the DO. Under the new rule, we have to verify the genuineness of the certificate of all the parateachers, the persons. When we wrote the letter to the Jack reported back that उपयुक्त विषय आपके पत्रांक स्वयंसो के संबंध में माध्यम से सत्यापन के लिए प्राप्त अंक प्रमाण पत्र की जांच परिषद अभिलेख में इनके परीक्षा फल के संबंध में जो स्थिति है विवरणी अंकित है। रोल कोड स्वयंसो सेम है हुजूर, क्रमांक स्वयंसो, वर्ष स्वयंसो, सरोज कुमारी सिंह, रामनाथ स्वयंसो। नोट, आपके द्वारा प्रस्तुत अंक पत्र की छाया प्रति के अंकित रोल कोड संख्या 9132 रोल कोड नंबर 67 वर्ष 2002 ए छात्र कच्चू उरांव, कुल प्राप्तांक 419 श्रेणी सेकंड डिवीजन दर्ज नहीं है।
We can't resolve it in writ jurisdiction. Go and file a civil suit.
So your lordship, counter affidavit.
No, counter affidavit by the college is also not sustainable.
Your lordship,
No, there is a very serious dispute.
No, your lordship, there is no serious.
No means.
Your lordship, state authority is relying that the document.
As per their records, they are relying on their records. As per their records, your name does not figure. As simple as that.
Your lordship, kindly have a look to this.
I am looking at it. We cannot resolve this dispute by any means.
Your lordship, direction will be given upon the Jharkhand Academic Council to look after the matter.
No, what they will? They have already given a report after verification.
I am stating in my your lordship's reply that these are misleading, your lordship.
These are misleading. Then therefore, if they have already verified it, they have given a report, then this cannot be. You have your remedies wherever you want to.
Your lordship,
but in writ jurisdiction, we cannot resolve.
Your lordship, my service, your lordship.
You have chosen a wrong forum. Writ is not the remedy under such circumstances.
Your lordship, the court has a jurisdiction. Your lordship, to entertain this type of writ petition.
We cannot resolve it through writ jurisdiction.
Your lordship, kindly have a look to the counter affidavit filed by the Maulana Azad College, your lordship. May I read, your lordship? Paragraph number 30.
Para number?
Para number 30.
Para number 13.
Para number 13.
Yes.
Respondent number 10. Maulana Azad College.
Yes.
Your lordship, further answering respondent for the interest of justice wants to bring some facts which are necessary for proper adjudication of the presented application. Since the admission register has been verified, which shows that read petitioner is found regular student of the college, but one another name figured in tabulation register prepared by the Jharkhand Academic Council, namely Saroj Kumari Singh, whose roll number is shown as same as the read petition. Her name has not been found in the admission register of the college. And other document of said Saroj Kumari Singh prepared and sent by the Jharkhand Academic Council vis-a-vis marksheet, migration certificate and provisional certificate are still lying with the college. And till date, some same document of the said Saroj Kumari Singh have not been claimed by anyone. Your lordship, college is admitting that I am the regular student of the Maulana Azad College and I have cleared the intermediate of arts examination. Provisional certificate, every certificate has been issued by the Jharkhand Academic Council. That has been obtained by me, your lordship, from the college. And we have already served more than your lordship 20 years being a para teacher. And upon the fake report given by the Jharkhand Academic Council, my services have been terminated. Your Lordship, I am facing a crude financial problem. I have given 20 years of my service, Your Lordship, to the state authority.
This para 8 and 9 of the Jack counter affidavit, Lordship, may kindly see this. Counter filed by the Jack. This is college में Lordship, but the question is the registration authority and the examining authority. That is the Jack. Jack is reasserting was kindly see para 8 and 9. The Jack counter, page 5 onward, Lordship. That it is most humbly stated and submitted, the answering respondent have verified the result of the roll code number such and such from the record wherein it was found that the student named Saroj Kumari Singh, father's name such and such, has obtained 449 marks, second division. The report of the same verification was sent by the answering respondent by letter number such and such dated 9/12/20 to District Student of Education, Ranchi. Verification was done on 8/7/23 and found later also verification done that the details of the petitioner does not match with the record presented Jharkhand Admin Council. Next paragraphs. That it is most humbly stated submitted that reference to this writ petition, the answering respondent has received the verification report sent by the Sacred Institution via Gmail dated 19/5/23. The report said that as per the result, Master of Annual Examination 2000 roll number such and such, named Saroj Kumari Singh.
What is the secret?
The secret plus it
What
appears
is
that there
secret
is a sale expert committee.
Expert committee.
There is a committee to resolve the grievance. The grievance, it was taken by the committee also, by the board, and it has been found to be not matching the records. So this was rightly fallen from my lord's serious disputed question of facts. Requires evidence.
It cannot be resolved in writ jurisdiction, and merely asking you to file a representation is not going to serve the purpose because they have already done it. Now you have to go to the civil court and get all the records, whatever you want, you can call for the records, and then only the court will resolve this issue.
Your Lordship, let the Jharkhand Academic Council, Your Lordship, in view of the still, Your Lordship, the document has been submitted, Your Lordship, by the department itself, by the state government, to verify the same.
They have already verified.
School, Your Lordship, she is not the student, Your Lordship. One Saroj Kumari Singh was not the student of Maulana Azad College. Admittedly, I am the regular student of Your Lordship.
Firstly, we do not know whether this particular roll number was forwarded by Maulana Azad College only.
Yes, Your Lordship, kindly happen. What has actually happened?
Where is that?
Your Lordship, counter affidavit page number 9, Your Lordship, that the document which has been enclosed by the
Page number?
Page number 9.
Of counter affidavit of?
Counter affidavit filed by the respondent number 10. Your Lordship, this makes everything clear. What has happened? And who was the wrongdoer, Your Lordship? It clearly appears from these letters. Your Lordship, with due respect, I have to draw your kind attention regarding the following fact. On the basis of tabulation register issued by Jack, Ranchi in the year 2002, both Kachu Ram and Saroj Kumari Singh had declared to be passed as per the record available in the college. Number 2, that in the year 2002, 2 tabulation register was issued by the Jharkhand Academic Council. Third, in one tabulation register of the year 2002, there is name of Kachu Ram against roll number such and such, roll code number such and such, page number such and such.
You just come to Annexure 5, page 34. What is it? नाम संशोधन का आवेदन प्राप्त हुआ.
Yes, sir. Your Lordship, this is the letter written by the Jharkhand Academic Council to the Pracharya Maulana Azad College. Jharkhand Academic Council, this letter has been written by the Joint Secretary, Jharkhand Academic Council to the Principal Maulana Azad College, wherein, Your Lordship, it has been stated, Kachu Rao, roll number such and such, पंजीयन संख्या such and such, परीक्षा वर्ष 2002 का नाम संशोधन का आवेदन प्राप्त हुआ है. संशोधन हेतु छात्र का इंटर का सभी मूल प्रमाण पत्र एवं मूल नामांकन पंजी की छाया प्रति जिला शिक्षा पदाधिकारी द्वारा सत्यापित परिषद कार्यालय को आवश्यकता है ताकि नाम संशोधन हेतु उचित कार्रवाई किया जा सके। चूंकि मेरे ओरिजिनल सर्टिफिकेट में सरोज कुमारी सिंह का नाम इंटर हो गया है, इसलिए दिस लेटर हैज बीन रिटन बाय द झारखंड एकेडमिक काउंसिल।
For the learned counsel for the parties, this writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner is in possession of all the original documents to substantiate that the petitioner was admitted. The petitioner had passed the matriculation examination in the year 2000 from Government High School, Kanti, and thereafter he had taken admission in Maulana Azad College, Ranchi, in Intermediate of Arts with college roll number 324 for the academic session 2000-2002. And he was a regular student of the college. And had appeared in the examination of Intermediate of Arts held in the year 2002 with roll number 30058, roll code number 9132, and cleared the examination on second division, and result was also published by Jharkhand Academic Council, Ranchi. And there was no discrepancy with regard to details of the petitioner. However, when the documents were sent for verification from Jharkhand Academic Council, it has been reported that the roll number and roll code belongs to one Saroj Kumari Singh, and the same does not belong to the petitioner. The learned counsel has submitted that a counter affidavit has been filed by the college in support of the petitioner. He has also submitted that the name of Saroj Kumari Singh does not find place in the register of the respondent college. The learned counsel submits that there appears to be some error committed by Jharkhand Academic Council in the matter of entering the name, and this fact could be verified only when the authorities from the college with all supporting documents, including the document relating to sending the list of the candidates to Jharkhand Academic Council, is placed before the competent authority of Jharkhand Academic Council so that the entire dispute can be resolved. He also submits that if any certificate has been issued in favor of Saroj Kumari Singh, a copy of the same must also be available with Jharkhand Academic Council, but no certificate with regard to Saroj Kumari Singh has been brought on record by Jharkhand Academic Council. Right? Considering the nature of dispute involved in this case, this court is of the view that such disputed questions of fact cannot be resolved under writ jurisdiction. But at the same time, the life and liberty of the petitioner is under stake, and one attempt is required to be taken so that the principal of Maulana Azad College, Ranchi, and the director of Jharkhand Education Project Council. Director?
Academic Council.
Okay. And the
academic council जहाँ से इनका certificate का verification आया.
And the Secretary of Jharkhand Academic Council Ranchi may sit together with the records so that the verification be done once again. And if the Secretary Jharkhand Academic Council finds that there has been some error on their part, based on the documents to be filed by the respondent college, appropriate steps be taken. And if appropriate steps be taken so that the grievance of the petitioner is redressed. However, everything will depend upon the production of documents by the respondent college. The Jharkhand Academic Council shall also, during the meeting, the Jharkhand Academic Council shall also produce a copy of the certificate which might have been issued to the candidate, namely Saroj Kumari Singh, and the backup documents or records in connection with her candidature. Accordingly, the petitioner is directed to approach petitioner as well as who is appearing for Maulana Azad College. You will cooperate? He is your candidate? Yes. The petitioner as well as the principal of Maulana Azad College Ranchi are directed to appear before the Secretary Jharkhand Academic Council. I'll give a date within a period of 15-20 days. On 8th of April, upon with their original documents, upon their appearance, the Jharkhand Academic Council, with the assistance of the petitioner and the respondent number 10, shall verify their records as well as the records of Jharkhand Academic Council and pass a reasoned order after granting an opportunity of hearing to the petitioner. Within a period of 1 month from the date of their appearance. At best, इससे ज़्यादा आपके लिए कुछ नहीं कर सकते.
हमारा सर्विस टर्मिनेट हो गया है.
टर्मिनेट को आपको रेस्टोर कर दें यहाँ से.
तो ये
नहीं कर सकते.
अपन वेरिफिकेशन ऑफ द
नहीं. Everything will follow thereafter.
Genuine आएगा तो he will approach.
Everything will follow thereafter. If the documents of the petitioner is found genuine, all consequences shall follow.
Yes.
That's it.
This case at 4 p.m. Item 7, WPS 3734 of 2023.
In this case, I challenge annexure 1, which is a charge sheet issued to me, madam, for awarding a major penalty.
It's a charge sheet.
Annexure 1. Lordship comes to annexure 1 at page 22, madam. और the very opening sentence says, madam, रेलवे सुरक्षा बल नियम 1987 के नियम 153 के अंतर्गत आरोप पत्र जारी करने के नाम दीर्घ दंड आरोप पत्र एवं स्थान निर्माण. मतलब my first argument would be that they are proceeding with a predetermined mind that a major penalty has to be awarded. the petitioner
Yes, continue.
The petitioner is a constable Malad employed, he came into service on 6th of April 2005. Malad, a charge sheet was issued to him on 26th of May 23.
Then what is your date of appointment?
Just 6th of April 2005.
6/4/2005. You are a constable?
Yes. Malad, in 23, rather to be precise, on 26th of May 23, the petitioner was issued a charge sheet. May I invite your lordship's attention to the charge sheet, my lord. The first line I have already read, my lord. My lord. Now your lordship may come to the annexures of the charge sheet, my lord, at page 24. That will show the charges, my lord. My lord, आरक्षी संजीत कुमार कर्मचारी संख्या सचन सच रेलवे प्रोटेक्शन फोर्स पोस्ट गोमो आरोप के अनुच्छेदों आरोप घोर अनुशासनहीनता कर्तव्यहीनता आदेश की अवहेलना एवं अविश्वास आचरण जिससे आरक्षित संजीत कुमार कर्मचारी संख्या सचन सच के विरुद्ध निम्न आरोप लगाए जाते हैं। आरक्षित संजीत कुमार गोमो को निम्न घाट रेलवे स्टेशन में कैंपिंग ड्यूटी दौरान 20/10/22 को गोमो पोस्ट के क्षेत्राधिकार में हो रहे दोनों परिधान स्थलों में बिना किसी प्राधिकार के मौजूद होना इसकी संदिग्ध भूमिका एवं गलत अवधारणा का दर्शाता है। चार्जेस I was not required to be present at the site of auction, my lord. I was present, my lord. Now, if your lordship sees, comes to the next page, my lord, page 25, my lord. Next page. आरोप का अभिकथन दिनांक 20/10/22 को गोमो पोस्ट के क्षेत्राधिकार में 2 स्थानों इलेक्ट्रिक शेड एंड टीआरएस गोमो में परिधान हो रहा था।
This is auction. परिधान is
Probably,
auction.
my lord, so far as my
Or allotment.
I think it's auction. I'm
You
not
must
sure.
know.
परिधान is, I didn't get the exact word in English word for it. परिधान स्थल पर श्रीमती सिंपी कुमारी निरीक्षक प्रभारी
So why should we entertain
Well,
this
I was
petition?
I'll show the arbitrariness, my lord.
No, it may be arbitrary,
Yes.
but the point is that at this stage, how they have already.
But I'll challenge the authority also. My second leg of argument will be the authority of the person issuing the charge sheet. For my first,
He is not competent.
no.
So that is a fair argument.
Yes, so then I'll come to it.
But you see, this malified etc. we cannot.
No. The inspector on whose basis the allegation is made, she says that he had come to Gomo with my permission to fill up a form.
No, that is a separate thing.
And my lord,
She says that she will be your defense. Right? On the
Yes.
face of the allegation made in the charge sheet cannot be quashed. FIR के हिसाब से चलता है. FIR quashing.
FIR quashing में होता है होता है ऐसा नहीं होता आज
But defense cannot be looked into.
No, I'm not saying that defense.
So therefore she said that she came there, you came there with her permission is something which you may have.
And then left the venue. I was not there.
Therefore this version she will come and say so in the inquiry.
She has said
Not
so in
before
the
this.
preliminary inquiry. She has said so, and despite that, my point is, my lord, despite her making a statement in the preliminary inquiry, that
You just come to the point of jurisdiction.
To the
Point of jurisdiction that he does not have an authority to
Jurisdiction.
issue you charge sheet. And where is the point raised in your writ petition? And
Yes,
we will see
I
the
have
reply.
taken it.
Where is it?
Just.
First show me the point and then we will see the reply. Which paragraph?
Just in the rejoinder also.
No, not rejoinder. We will not go by rejoinder. You show me in your writ petition. That the issuing authority does not
Yes,
have the
you also may come to para 31.
Para 31. Yes.
Well, that in a further guidelines issued by the Chief Security Officer South Eastern Railway by circular number such and such, it has been provided that the disciplinary authority after conducting preliminary inquiry shall not directly issue charge sheet and appoint inquiry officer. Since in such cases there can be chances of bias by the disciplinary authority. In my case, both the things have been carried out on the same date.
The same date is another thing.
Yeah, I'm coming to that also.
No, where is that circular? This circular?
My lord, Railway Servants Discipline and Appeal Rules 1968. I could lay hands on it today, my lord. My lord, Rule 2 says, my lord, who will be the disciplinary authority? The charge sheet should be issued by the appropriate disciplinary authority prescribed in the schedule. It is also essential that the charge sheet signed by the disciplinary authority himself and not by any other lower authority or by him or himself. The provisions of Rule 8 has to be kept in view while ascertaining whether the charge sheet has been issued by the correct authority. In respect of non-custody, in the remand affidavit, I have brought on record that the officer who has issued it, he is Assistant Security Commissioner.
Therefore, you see, you make your entire case, this is the practice of Jharkhand High Court.
Yes.
The entire case is made out in the rejoinder.
No. In the
You show us who is the authority, who has issued it, where is it? The foundational fact is totally missing in your writ petition. You cannot make out a case by rejoinder. Rejoinder is something, if they bring something on record, then you can just
para 39. Your lordship may come to para 39.
Para?
39.
39. Yes.
That it is further submitted that as per the rules, the inquiry officer in a case of departmental proceeding against an employee of the rank of constable has to be conducted by an Assistant Security Commissioner. Whereas in the case of the petitioner, the proceeding is being conducted by an officer of the Assistant Security Officer, his ad hoc manner. So, Assistant Security Commissioner, who is doing Assistant Security Officer? I have taken that.
He is the inquiry officer.
He is the conducting.
He is the conducting officer.
And there is no presenting officer.
That's right, that is a separate thing. They will have their own presenting.
Now in the remand I have brought on.
No, just a moment. He is the assistant security. You are shifting from one point to another. In this, you say that disciplinary authority, after conducting the preliminary inquiry, shall not directly issue charge sheet.
That is one point.
No, where is that circular? You have not completed this point.
Yes. No, your lordship wanted to see.
No, I wanted to see both. I want to see both. First, you satisfied para number 31. You satisfy para number 31.
I will make that circular in the rejoinder. In the counter also they have an issue. Rule 146 and 147 they have quoted, madam. In the counter also they have an issue.
Where is it?
Okay. (151).
Where is it? Page number.
That rule I have not annexed the different parts of it. 151 has not been annexed.
You are arguing in support of your statement
No,
made
it's a
in
rule,
para
madam.
number
Therefore,
30.
it is the rule, madam.
So show me the
No,
rule.
I'll show it from the book.
Show it from the book.
Yes. 151.
You read it. I'll take it.
Disciplinary authority. The disciplinary authority in respect of any enrolled member of the force for the purpose of imposing a particular punishment or the passing of any disciplinary authority shall be the authority specified in this behalf in Schedule 3, in whose administrative control the member is serving and shall include any authority superior to such authority. Clause 2. The disciplinary authority in case of an enrolled member of the force officiating in a higher rank shall be determined with reference to the officiating post held by him at the time of taking action. 152 is 152.
There is nothing, so far as whatever you have read, there is nothing to support your paragraph 34. Para 31. It does not support para 31.
We say that Assistant Security Officer is not the...
You have made a specific statement that if the disciplinary authority has conducted some preliminary inquiry, then he shall not issue the charge sheet directly. And what you have read is that it is the disciplinary authority only who has to issue the charge sheet.
No. Probably I have not been able to communicate.
No, you read it once again for yourself.
151.
Whatever you have read, you read it again.
31 I am reading again, madam. That
The
is-
learned counsel for the parties are present. The counsel for the petitioner is directed to prepare a short note quoting all the relevant provisions
Yes.
which he seeks to rely upon, and also also refer to the amendments in that regard made in the writ petition. In the writ petition.
And the conclusion.
No,
It's a continuation,
rejoinder.
madam.
No, rejoinder cannot be a new ground. You cannot raise it.
No, it's not a new ground, it's only an elaboration.
No. It must be backed by your
Yes, yes,
statement.
it is done in the writ application.
So you raise it from the writ petition.
This rule is very specific, my lord, so far as the jurisdiction which has been exercised by the authority, my lord, he has issued the charge sheet against the petitioner.
The disciplinary authority.
Disciplinary authority. My lord, the schedule empowers him, my lord, so far as the power which is being conferred upon a authority, my lord, to initiate for punishment of minor punishment, my lord, he can also initiate proceeding, my lord, so far as the major punishment is concerned. Therefore, the point which my learned friend was arguing that the major punishment, the notice has been issued, that can be done in terms of 152.2, and the schedule itself specifies with respect to the power which has been conferred upon Assistant Security Commissioner.
Yes, but he is the person concerned, he is not assistant security officer, he is an ad hoc basis.
Whatever, my lord, that I also clarify.
So even if
He is holding that post, my lord.
I
It is
have
not-
judgments to that. I have judgments to that.
cite it right.
Yes.
Yes, sir.
Where is it?
The rule
Additional charge may, if somebody is there, he cannot do it.
No, the point is the one who is officiating on ad hoc basis, he cannot take the, he is not competent to do it.
And so from the rule itself.
Madam, I was going through digest of discipline, appeal and conduct rules, madam. They say, madam, what the statutes say. An officer who is promoted on ad hoc basis is not competent to initiate departmental proceeding. He
From
cannot.
where are you reading it?
Madam, I just
It's a rule, or it is just a one-liner from one judgment.
You are not just bear with 1 minute. I just say an officer who is promoted on ad hoc basis is not competent to initiate disciplinary proceeding. He cannot exercise the powers of a regularly promoted officer. This is on the basis of judgment passed in Lakshmi Narayan M. Sarma versus Union of India. Today I tried to search out this judgment, but I could not. Therefore, I satisfy your lordship on this point also. But they have given a judgment, my lord. It cannot be redundant. Lakshmi Narayan Sarma, Lakshmi.
भाई आप पढ़िए वो one-liner.
Yes.
हम नहीं पढ़ सकते.
No. It is backed by a judgment, my lord.
We do not know.
I'll give
You read it from some annotation, one line.
No.
Just one line only.
But today, in fact, I have come back today. I was not here, man. I come back today, and thereafter I didn't get sufficient time. I'll give the judgments, along with the compilations.
So there is stay of the Department of Justice.
कल सुनेंगे आप कुछ नहीं सुनेंगे आप.
मंडे को सिनॉप्सिस दे.
नहीं कुछ नहीं आपको सिनॉप्सिस का भी जरूरत नहीं है हम सुन लिए आपका काम.
ठीक है. कल.
We'll continue tomorrow. It is already going to be 4:30 now.
Yes.
देखिए WPS number 3734 of 2023 सबका appearance record. Let this matter be posted tomorrow for further hearing. आपको जो रूल देना है दे दीजिए. आपको जो भी रूल आप साइट करने हैं आप हमको.
It is already in the counter. It is in the counter.
You will not refer to anything which is beyond the records.
Yes.
Any rule.
No, some rules I will.
You just tell us what rule do you want to cite.
I'll give it the first one.
आपकी तरह तेज नहीं है. बहुत स्लो काम करता है मेरा दिमाग.
Railway Protection Force.
Yes.
Act, the rules is there.
Railway Protection Act.
Railway Protection Force rules. Rule 151, 152, and.
You have a copy? Okay, ये जरा निकाल लीजिए Railway Protection Act.
You also may go through 146, 147.
Of the same rules?
Yes.
Yes, sir.
कल 2:15 बजे सुनते हैं.
हाँ.
ये Schedule 3 है इसको मार्क.
इसको मार्क करके जरा लगा दीजिए.
Schedule 3 में the right corner में post किया हुआ है. The authority, disciplinary authority rank has been given. The punishment which can be awarded is given. Rule 152 subclause 2 itself. 152.2 is specify what are the disciplinary authority who is empowered to give minor punishment can also initiate proceeding and issue charge sheet with regard to the major punishment.
That's
Therefore, these two schedule
the
3
other
and
part he's
152.
raising is that officer and
Yes, well, that will be clarified from there also. So far as the schedule is concerned, explanation 4 speaks about so far as the regular post is concerned, that is required to be only with regard to the appellate authority. But so far as the disciplinary authority is concerned, even the in charge the interpretation can be done to that effect that the even in charge can do so far as that part is concerned. Because so far as the appellate power is concerned, that can be exercised only by the regular appointees. That has been clarified.
I'll be relying on another
which
memo of theirs, which is
heard the
there.
learned counsel for the parties at length, pose this case for further hearing.
At 2:15.
At 2:15. Let me just go through the records.
Yes, well, that is
on the basis of whatever you have submitted. I'll have an open mind, don't worry about it.
No, definitely, my lord, once the question comes to the jurisdiction, my lord, it should be very
It has to be
clear.
decided.
Yes.
Jurisdiction has to be decided. All good.
Passover case item 23, WPS 1614 of 2023.
Is there any Passover case? Who is there in this case? Are you appearing? What is the matter? No, this is not cancellation of. It is only to accept the joining. You have filed your counter.
Item 23.
Counter is
Item 23.
counter has been filed, but it is not sufficient.
23.
Passover.
Why do you need?
Lordship, in this matter,
What is your stand in the counter affidavit?
Lordship, there is a matter of unauthorized absence. Petitioner has for 6 day leave,
Yes.
and he has been absent for more than 6 years.
More than 6
6 years.
6 years?
Yes, Lordship. Thereafter, he was saying that he was became mentally ill, and there was no intimation from his behalf, Lordship. Thereafter, he came after 6 years and request the respondents to accept his joining, Lordship. That has not been done yet. We will file, Lordship, further supplementary affidavit to that effect, Lordship. That whether he has been rejoined or departmental proceeding has been initiated against him or not, Lordship, on that point.
No further affidavit will be required. We'll post it tomorrow. Post. Your case, where is the counsel for the other side in your case? Is he there?
He's not here, Lordship.
We have posted it tomorrow. We will pass the order.
Appearance
Sorry?
appearance
It will be marked, certainly. इनका appearance memo दीजिए. Serial number कौन सा है?
Item 6.
6. The learned counsel for the parties have been heard at length. Pose this case tomorrow for further hearing. We can think of, imposing some kind of cost on the other side, such that you are compensated to some extent. But post-retirement benefit is difficult. So this aspect we need to.
Only pension yours.
I know, only. Even pension would be difficult because you have not discharged your duties for 10 years. We will figure it out what is to be done. I'm just still in the process of thinking. That is why I have not pronounced it.
बस दे देंगे
उसका रिमेनिंग जो है उसका
सर आइटम नंबर 23 जो वाको भरा लिए थे उसका कब निकलना होगा?
अभी तो 23 कॉल किया गया, आप नहीं किया अभी, जस्ट अभी लास्ट केस
अभी तो वही कॉल हुआ
लास्ट में
हाँ आप नहीं आए तो टुमारो हुआ है, टुमारो आ जाइए।
किसके तरफ टुमारो? अच्छा
किसके तरफ से
कब जाएगा रिमेनिंग
तो एक्सीडेंट हो गया तो
रिमेनिंग कब जाएगा?
कौन सा सही है?
जितना जो बचा हुआ है
डिफरेंट डेट्स को जाएगा, एक डेट में नहीं जाएगा, मोस्ट प्रॉब्ली आप अपील में जाने का
ले लीजिए, इस पर दे दीजिए।
ठीक
उस पर बढ़ा तो वहाँ पर ये लिस्ट होगा।
सर
हाँ सुनो ना,
अच्छा इसमें आपका कौन सा नाम है? 4 आदमी ने भेजा।
मेरा अंकितेश कुमार सेकंड है।
अंकितेश
अनिल सर का डाल दिया, 2 लोग का एटलीस्ट डाल दिया, अनिल कुमार अंकितेश।
ऐसे हम दे दिए हैं आप।
लैपटॉप आया, चार्ज नहीं लगा हुआ था।
ठीक है सर, हम मनी चेंज हो गया क्या?
हाँ सर, इससे एक बार आ गया।
तो पहले भी था।
हाँ सर,
शुरू से आ गए इधर भी अभी आएंगे।
बस शुरू से
आसान नहीं है ये, दूसरा क्यों नहीं करेगा?
जैसे भी कहिए हमारे कब लोग थे इतना दिन में तो टेंडर है सेविंग करने कंपनी को देना
बैठे ना, हाँ कौन वाला सिस्टम कीजिएगा, मतलब कहाँ बनी, देखिए एक ये सिस्टम में करना होगा और एक लैपटॉप में करना होगा, ठीक है? ये लिस्ट ऑनलाइन रहेगा, एक लैपटॉप में जिसमें कंप्यूटर ऑन होगा
केस कर लाना होगा सर, काउंटर फाइल करना था, सीरियल नंबर 43 में है।
टुमारो
एडमिशन के स्टेज में है, सीरियल नंबर 43 मनोज कुमार सिन्हा। स्टेट की तरफ से